Hello and welcome to today's Edu-Series session. Thank you for bearing with us and we apologize for the late start. My name is Irene Mohoro and I am the chair of the Media and Communications Committee for Africa and the Moot. We are a volunteer-driven non-profit organization that is dedicated to enhancing the representation of African practitioners in international arbitration. We achieve this from the ground up by empowering African students with the skills and resources they need for a meaningful participation in the Willem C. Vis Moot. As part of this initiative and in collaboration with our amazing partner, the Arbitration Channel, we host the Edu-Series, an open and free access educational platform that gives students the essential educational and training materials they need to excel at the Vis Moot. Today, we are thrilled to have an outstanding guest with us, and without further delay, I'll pass it on to my co-moderator, Carlo, to introduce our guest.
Thank you very much, dear Irene and dear André. Welcome to Africa in the Moot. I'm also glad to welcome all the participants who are connected online to this session of the Edu-Series of Africa and the Moot that is titled Pleading, the CISG in Oral Arguments. I am Carlo De Stefano, Assistant Professor of International Law at Roma Tre University in the Department of Law and a member of the Education and Training Committee of Africa in the Moot. Now, let me introduce our stellar speaker, Professor Janssen. André Janssen is Chair Professor of European Private Law at Radboud University in the Netherlands, and he currently holds the Venland Scholar Chair at Zhongnan University of Economics and Law in China. He has authored a number of publications, more than 170, on private and commercial law, private international law, international commercial arbitration, etc. He is one of the leading authorities on the Convention on the International Sale of Goods. Moreover, he is a co-chief editor of the European Review of Private Law, and he is on the editorial boards of various journals, including the International Arbitration Law Review and Opinio Juris in Comparazione. In 2023, André was elected rapporteur by the CISG Advisory Council for the forthcoming opinion on smart products under the CISG. And he is also a council member of the European Law Institute and co-chair of its special interest group on digital law. Now, André, in thanking you again for being with us today, I'm very pleased to give you the floor without further ado. Thank you.
Thank you very much. So I'm sharing my screen now. I hope that was going to work. And let me check. So that should be, let me see, where is it? Let me see, Windows, that's the right one to share. All right. So how much time do I have, Carlo?
Considering the delay, up to you. We can consider 40 minutes approximately.
Yeah. Okay. That's fine with me. Yeah. So then I have more things, but I can always adjust. So okay. Thank you very much for the very kind invitation, for the very kind introduction. Very pleasured. It's a pleasure to be here. And without further ado, so pleading the CISG in oral arguments. Well, I'm, as you might know, no, you don't know, but my mom is not a lawyer. Yeah, and I always ask, and she's always asking me, well, what is that Vis Moot? What is that? Why are you going always to Vienna? Why all these pre-moots and why students do that? And I'm always telling her, this is like the Olympic Games for law students. Yeah. So the entire world meets there. One case, and it's like a marathon. It's not a sprint, it's a marathon. You need different skills. And I like the idea of these Olympic Games. And once you are there, either at the pre-moot or in Vienna or a local moot, you will see how many people are there and how dedicated they are. And I like this idea. So my mom always also then understands more or less what I'm doing there. And so my agenda, I will probably cut it a little bit. So the agenda is as follows. Before the oral arguments, then it is your turn to speak. What are you going to do? Then how to address questions of the arbitral tribunal. Then rebuttal and surrebuttal, teamwork, and after the oral arguments. Probably I will not be able to address the two hands-on CISG examples which are prepared, but I'm very happy that if you want to have my slides, I'm very happy to share them. It's a right to me, or I'm also sending it to the organization, so that's perfectly fine. And before the oral arguments, so in general, so what you need to bear in mind when you are when you are participating in the Vis Moot, you are an ambassador. You are an ambassador of your university, and maybe even of your country. Yeah, and that is something you need to bear in mind when you are starting these journeys. So you are not just an individual student. In general, I think somebody's mic is still on, so maybe it can be muted. And then, first of all, and as I said, I think I'm doing Vis Moot for almost 25 years. Not a little bit more than 20 years. So already a long time. So, and what I see is, in general, you should never underestimate your opponent. Yeah, if you're there, regardless where they're coming from, never underestimate them. I have seen teams which were supposedly weak, and they were extremely good, and also the other way around. So very prestigious universities, and they did not impress me at all. So which also means to flip the coin is, don't be afraid of opponents. If there are big name universities, don't be afraid. They're all sitting in the same boat. What you should do is you should know, if possible, it's not always possible, to know the members of the tribunal you are facing. Yeah. So what is their profession? What is their expertise? What is their legal system? What are their publications? And do the publications focus on something which is also a Vis problem? Yeah, for the legal system, common law persons, common law arbitrators are acting differently, are asking differently from civil law persons. Also, the profession is different. Yeah, makes a difference. So, the profession, if you have a real practicing arbitrator, or if you have a professor, they ask different. So be aware of, let's say, know your enemy. Yeah, but in the best case, they shouldn't be your enemy. Then do not be afraid of last-minute changes. They will happen, 100%. Yeah, so there will be a different arbitrator, or maybe even all three are different. Maybe you even get last minute a different opponent, and the venue or time can change. So be aware that is going to happen. At the day of the oral arguments, what should you do? Well, of course, needless to say, you should dress professionally. Then have the binder ready and prepared. If you have the post-its ready, so the post-its, so to the exhibit you want to refer to, have it ready. Have a watch ready for timekeeping. I would suggest do not use a cell phone. First of all, there are arbitrators, they don't like to see a cell phone on, they don't like to see cell phones. And I'm also one of the arbitrators, I don't like that very much. And on top, suddenly, and it happened to one of the teams, that the cell phone went off and completely distracted the team. And before they were good, and then suddenly the cell phone rang, and it went downhill from then on. Don't forget your business cards. Have your business cards ready. Check before you leave. Then know the address of the venue. Sounds very basic. Still, don't get stressed. Don't get stressed if you're in different city you don't know. Don't get stressed, and therefore be there on time. Be there at least 30 minutes before the oral round starts. So you come there relaxed. So, okay, before you're entering the room, so you arrived at the venue, what should you do? First of all, you introduce yourself to the members of the opposing team. Then, well, that's of course a courtesy. And swap business cards with a member of the opposing team. So therefore, have the business cards ready. On top, and for the rundown of the entire oral round, it is of importance that you discuss with the opponent the time allocation and the rundown. Who goes first? What comes first? And so on. In general, of course, be always kind and wish the opponent good luck. Now you've entered the room. Arbitrators, in the best case, they are already there. And you should then introduce yourself to the tribunal before the oral arguments really start and give them their business card. That's helpful for the arbitrators because it makes things easier for marking, because we have to fill in particular sheets, and therefore business cards are useful. On top is, in addition, don't have a messy table. Don't have too much stuff. Have the binder, have some sheets of paper, have a pen ready, and if you want some water, and so on. But make sure it is not messy, because you will be stressed, and a messy table causes additional stress. What I said, no cell phones, according to me, on the table. And in general, that's for all team members, put them on the silent mode. And take it seriously. Be professional, show that you are ready, and that this is not a game. Then wait for the presiding arbitrator to give you the word, and said, he's addressing you and said, okay, now please start. Then it is your turn. So now it's your turn to speak. So how should your submission look like? First of all, introduce yourself again and the teammate, at least the first speaker. Tell the arbitral tribunal who is doing the merits, who is doing the procedure, and also which client you are representing. After that, what I like is a crunchy introduction of the case. So why are we here at all? In the best case, you are good at storytelling, and you tell the story why we are here, and that helps. Normally, people from with common law background, they're quite good at storytelling, and that is of importance to have a nice introduction to the case. Then also say, and these are my submissions. Yeah. And then after that, you are starting with the sentence, moving to my first submission. That is the symbol for the arbitral tribunal. Okay, you are talking about the first submission. After then you are talking about the first submission, then you give the arbitral tribunal an interim conclusion for that first submission. Then again, new sentence, or then another sentence, moving to my second submission. Flags out, also very understandable, very easy to understand for the arbitral tribunal. Okay, now it's a new topic, new submission. You then again interim conclusion for that second submission, and then you need to wrap up, even though you are under time constraints. You need to do the final conclusion to wrap up. And this is, in a nutshell, the structure of your submission, of your oral arguments. About the timing. The timing is you have 14 minutes maximum, and always bear the time constraints in mind. Always know where you are. That is something I see at many oral hearings, that somehow they get questions and then the speaker completely forgets the time. And then the teammate the co-counsel tries to hint it's about time. And then the speaker is stressed, the counsel is stressed and doesn't realize it. So always bear time in mind. Do not rush through your presentation. So even though you have time constraints, you should not rush. In general, what is a problem normally is that I see that teams are preparing their submissions or their part for each speaker 14 minutes. Yeah, so they know they have 14 minutes and they prepare the entire part for 14 minutes. And that is not the reality. That only happens in a very rare case that you don't get any questions, which, by the way, is not good. If you don't receive any questions, that's not, you don't want that. Anyways, so what you need to have is you need to have a plan B, C, and D ready to adjust your submission. Yeah, so you need to have a plan B ready for maybe an arbitral tribunal, which takes just 2 minutes of your time. Then you should have a plan C ready if the arbitral tribunal takes 4 minutes. And then you should have a plan B ready, D ready for, okay, this is a very active arbitral tribunal. I have only 7 minutes. Yeah. So you need to adjust. You need to know what things to cut if you feel time constraints. If you're running out of time, what to do? If you're running out of time, you should probably around about 2 minutes before the 14 minutes end, you should ask for additional time, but be decent. I've seen teams which said, I want to have 10 minutes. Then that makes an arbitral tribunal angry. So you might ask for 2 minutes, better for 1 minute. Normally that's granted, especially if the arbitral tribunal is very active. Yeah, it's normally 1 to 2 minutes. It's not a problem to ask extra time, but you need to do it. Yeah, you may not just go over the time without asking for extra time. About timing, yes. About legislation, case law, legal literature, and facts. What is of importance is that you show the tribunal, in the best case also the opposing team, I master the applicable legislation, case law, literature, and facts. So what I like to see is when you give the tribunal the impression I am in full control. You can ask me whatever you want. I'm in full control of the situation. Don't lose that control. And therefore, first step is everything you cite properly. And that is very often a mistake by speakers. They invite the tribunals to ask questions because they are not precise enough or they make a mistake. So normally these kind of things, legislation, case law, legal literature, and facts is a source of questions if you don't do it right. And even if you do it right, it's nevertheless often arbitrary tribunals are still asking, and it's your chance to shine. Legislation. About legislation, you should cite properly. If, for example, if you cite Article 7.1 and Article 7.2, the huge difference. So you need to cite properly. Tell the tribunal that one article of the CISG is applicable and also why it is relevant, why it matters you are citing the article. Do not cite an article which at the end is irrelevant. This is important. Case law. Same thing at the beginning. So always ask yourself, first of all, is the case you are citing, is it applicable to the case? Does it cover? Yeah, is it of use and is it relevant? Yeah, or is it a sideshow? And so often what I see is that students are citing cases and they're not of relevance. Yeah. Then what is a general question often is the value of case law under the CISG. Remember, it is not a precedent system. Yeah. So is it a persuasive authority or what is it? What is the value of the case you are citing? So why is the case you are citing authoritative and why other case law is not? That is something which I believe is of paramount importance. Legal literature, same thing. So if you are citing legal literature, so why this is authoritative? Yeah. And why is maybe somebody who has a different opinion, why that one not? And whenever you cite an author, you should know everything about that author. So is it a professor? Is it an arbitrator? What did he do? Where does he work? Why is he an authority? Do not just drop names and you don't have any clue what that person is doing. You know everything about the author you cite, everything. Pronounce names correctly if possible. Yeah, that is nice to have. So I would try to do that. A problem I see very often is commentaries, which means that teams are referring to Kröll and to Schwenzer, but they do not refer to the commentators within that commentary. So then teams say, well, Schwenzer said this and that. And then it is, in reality, it is, for example, Franco Ferrari, who is one of the commentators within the commentary of Schwenzer. So what you are saying in that case is just wrong, because Schwenzer didn't say anything about that, but Ferrari. So, and that is not a good thing. Very often, what happens, often teams are often referring to CISG Advisory Council opinions. And as Carlos said, well, I'm a rapporteur myself, but you can often expect questions. What is the value of a CISG Advisory Council opinion? And do not overstate the value. Are these top world-renowned experts who form the CISG Advisory Council? Yes, this is true. But do they have like a mandate? Yeah, so no. So it is one opinion among others. Of course, well, it's a council, but still they don't have a mandate. So it's not as if this is an official document, or the opinions do not form official documents by the UN, for example. Facts. So the facts, very tricky in general. So you need to know which facts are relevant. Prioritize the key facts. You have 14 minutes. So check which facts you really need to support your position. And also explain to the arbitral tribunal why you think those key facts do support your position. Expect a lot of questions on facts, how to understand the facts. If you refer to key facts, do it properly. So know the page of the record. But as I said, do prioritize. Do not refer 10 times 2 pages, and do not bring the arbitral tribunal 10 times to a particular page, because you will lose a lot of time, and normally arbitral tribunals don't like it if it's too much. But you might do that 2, maybe 3 times, but you should not do it a lot more. So prioritize the facts and then explain why these facts you choose are relevant for your position. Advocacy style. What I see very often is that students rely on notes very much, and that should not happen. It might, okay, you are now at the beginning of February, you might still need the notes, but I would never read out loud your submission. I know you are nervous, and the arbitral tribunal knows you are nervous, but do not read. In a real practice case, if you have arbitrations, if the arbitrator reads out loud his submission or her submission, that's not very good. So have maybe 1 page, have the rundown ready. If you're nervous, you can still look at the rundown. Then, do not sound robotic. I know that students are sometimes they're just memorizing the entire submission. That's normally not good, because one question can completely distract you. Yeah, and if it sounds very robotic, it's that is normally disliked by arbitral tribunals. Avoid, if you can, that can happen, but try to look at it. record your own sessions and check how often I'm doing that, or do I have other tics I should avoid. Use adequate language. Yeah, there is no street language, no colloquial language. So it needs to be legal, formal English. Use your voice. Put an emphasis on something. So don't be, if you don't use the voice and you put an emphasis on something, then it's very boring. You have to imagine that sometimes we are having 4 hearings, 5 hearings each day. So then it's nice if you put an emphasis on something which is of importance. You can use silence but don't do it too much. But sometimes a little pause is good. You have eye contact all the time. Especially, first of all, it's nice as an arbitral tribunal that you keep eye contact. But also it's good to see the facial expression of the arbitral tribunal, because you can read normally if they liked something, if they disliked something, or if they didn't understand something. So you can explain without receiving a question. Body language is of importance. Don't sit too far away from the table, otherwise you will hang. Yeah. So be upright, and you can use your hands. And I know that there are some people, some countries, they use a lot the hands. I would suggest you can use the hands, but don't do as if it's karate. Yeah, the hands are there to put an emphasis on something. Then of importance is also advocacy style is give the tribunal time. If you refer to a page of the record, give the tribunal time. You look at the tribunal and see whether they found the page. It is very annoying that if the team is too fast and you are still not there, and normally I interrupt the team if it wants to go on, and I said, I'm still not there, please wait. In general, be confident, not arrogant. Yeah, that might sometimes be a thin line, but I've also seen some teams which acted arrogantly, and that is not very good for the marking sheets. In general, you are fighting for your client. You want the best result for your client. And so demonstrate that you truly believe that your client has the better case and that you want to win. But again, or not again, but never be aggressive. Never be condescending. Never raise your voice. Advocacy style is also prioritize your arguments. If you have 2 submissions to make, you begin with the strongest argument and you invest most of the time in the strongest argument. That in case of emergency, you might skip one argument and then maybe move to the next submission. But so take the strongest argument first. All right, how do you address? Yeah, you have done your 14 minutes, or not done yet, but during those 14 minutes, you receive questions of the arbitral tribunal. What do you do? First of all, anticipate questions. Yeah, you should know. Sometimes you can lure them to ask you if you want. Sometimes after a while, you have enough practice rounds. You did enough practice rounds, and you know which questions could come up. Don't be afraid of questions, but see the questions really as a chance to shine. I know it's difficult, I understand. But sometimes I can see good teams, they are waiting for questions. I can see their body language, they're very calm, and they are eager to receive questions, because that makes a difference. What I think is of importance is also sometimes try to understand the question of the arbitral tribunal immediately. I realize that sometimes teams are trying to buy time, and they say, well, I didn't understand your question. You can do that once, but if you do that a lot of times during one hearing, I believe is a strategy to gain more time. Therefore, try to understand questions immediately. Then try to really answer the question. Do not shy away. Do not answer a question which was not raised. Yeah, and because arbitrators know very well whether you answered the question, whether you at least try to answer the question or not. Then, questions about legislation, case law, legal literature, and facts are very common, as I already told you. But please do not invite the tribunal to ask you. Yeah. So everything you cite, you need to know by heart. May it be facts, case law, literature, and so on. Well, if you don't know the answer, yeah, you've done your best, you don't know the answer, then in that case, as an emergency exit, then say something. Then in the worst case, answer something or say something which does not really reflect the question, which does not really answer the question. But don't be silent. If you can, don't be silent. So that was the substance. Now, advocacy style. Do not thank the tribunal for questions. I have seen one very famous professor. I was with her on the tribunal, and she said, well, please don't thank me because I know that my questions are good. Don't do that. As I said, look as if you are enjoying receiving questions. Yeah, come, ask me, I'm ready. Then stay your ground. Yeah, if you are put under pressure, and you will be put under pressure, stay your ground, but don't be aggressive or stubborn. Yeah, stay your ground calmly. And that is something, the next point is keep in control of the discussion and time despite questions. So don't try that the tribunal is not hijacking your your oral arguments. It can happen, yeah, if they have a lot of questions, but I know it's difficult, but you should be able to keep in control of the discussion. You should be the master of the discussion. Yeah, and always try to keep your cool, if possible. Whatever they throw on you, whatever the arbitral tribunal throws on you, you should be cool. Rebuttal and surrebuttal. This is
excuse
yes.
me, André, can you hear me?
Yeah.
Excellent guidance on this very intricate issue of the questions that are posed directly by the arbitral tribunal at Vis Moot hearings. Now, more specifically, also for the sake of the order of the works, would you mind maybe now focusing on the CISG-based examples, and maybe we can also come back to other issues in the Q&A. What do you think?
I can. So I still have the rebuttal and teamwork after the oral argument. But if you want, I can do my examples.
And I'm sure that your practical guidance was so fascinating that we can go back also to the issues that are left in the Q&A.
Okay, fine. Okay, so let's do two hands-on CISG examples, also in the interest of time. So normally there are two things which if it's on the CISG, which always pop up, and that's the interpretation of the CISG and the interpretation of the party's conduct. So how do I interpret the convention? And then second is, how do you interpret the statements or the party's conduct? I think the mic is still on. So the interpretation of the CISG. Normally, the interpretation of the CISG of one CISG provision is often in the center of the Vis problem. Well, why is interpretation of such an importance for the CISG? Well, of course, first of all, interpretation is always important. Interpretation of provisions, and that's also true for national provisions. In particular, but let's do some more CISG issues, why interpretation has such a paramount importance. The CISG operates with numerous open terms. Fundamental breach. It operates a lot with reasonableness. Yeah. So therefore, the open terms need to be interpreted. Then we always need to bear in mind the CISG is a compromise. Yeah, it's a compromise between common law, civil law, but between other developing countries and so on and so on. So religious ideas and so on. So the CISG is a compromise. Then, in opposite to other laws, to other statutes, the CISG is aging. The core is of 1980, but the CISG as such is immutable. Yeah, it cannot be changed unless there is a new CISG 2.0 or there are other convention alongside with the CISG, but the CISG as such is, let's say, immutable. And the thing is that there is a danger of diverging interpretations. There is no CISG Supreme Court. And therefore, Article 7.8 says, well, we need to interpret the CISG uniformly and bearing in mind good faith and bearing in mind that we have to harmonize the international sales. And let's do an example. That is in a nutshell, the example of 1 year ago. And that's the following. So two parties who have their place of business in two different contracting states conclude a sales contract over a cargo drone. Those drones really exist. I'm not making these up. The drone can carry cargo up to 200 kilograms and need to be registered with national aviation authorities. The contractual relationship gets sour, and the question arises whether the applicability of the CISG is excluded under Article 2E of the CISG. And the wording of this provision is as follows. This convention does not apply to sales of ships, vessels, hovercrafts, or aircrafts. The question is the CISG excluded under Article 2E of the CISG? So how do you do it? Yeah, because there is, according to my knowledge, almost no case law. There is some legal literature, but not too much. And there is also no CISG Advisory Council opinion. Even if you want to interpret the CISG in the light of the UNIDROIT Principles, which I would not support, but also the UNIDROIT Principles, they don't tell us anything about it. So how do we do that? And we have 4 potential methods. The wording. Aircrafts. Is the drone an aircraft? Yeah. So is an aircraft somebody who needs to have a pilot? Yeah. Is that, or can also airplanes be drones which are just and they are where you just use remote. So the wording is I would say, well, aircraft is probably not so easy, yeah, but maybe flexible enough. The preparatory work, this is another method you can use. And you could argue, and if you see there, well, the CISGs of 1980, there were no drones yet back then. So probably the preparatory work also doesn't say a lot. There is another idea of the systematic position. So you try to interpret the provision in the light of the systematic position. But here, for that exclusion of aircraft, that also doesn't help a lot. So at the end is what remains is the teleological interpretation. Yeah. So the rationale of the CISG or of the relevant provision. And what is the rationale why the CISG put or excluded aircrafts from the applicability of the CISG? And here I said, well, of course you can go both ways. That's how the CISG problems are normally structured. One argument to exclude it could be because I told you that the relationship that the aircraft needs to be registered with national aviation authorities. So that you might argue, well, if it needs to be registered at national aviation authorities, then we should treat it as an aircraft. And you could, yeah. So there are many ways to go, but this is just how you could, or which methodology you could use to come to a conclusion. Of course, we are running a little bit out of time. Do you want me to do the other example?
Yes, André, go ahead with pleasure.
Yeah, all right. We had the interpretation of the CISG, yeah, and with drone, and Article 7.1 is of importance. And what about the interpretation of parties' conduct or statements? So the parties do something, and how do we interpret that? And here the relevant provision is Article 8. And Article 8 has a sort of subjective interpretation and says, well, as long as there is a meeting of minds, if the intent becomes clear and the other party knew or could have not been unaware of the intent of the other party, then we can interpret it, the will in that way. But so there must be a subjective meeting of minds according to Article 8.2, Article 8.1. If we don't do that, if we cannot do that, if we cannot extract an intent from something, then there is a so-called reasonable test. Yeah. So how would a statement or a conduct how would a statement or conduct be understood by a reasonable person in the same circumstances? Yeah. So that's the objective test. And one example. very fresh example. It's less than 2 weeks old. So two parties who have their place of business in two different contracting states conclude a sales contract. They put a provision in the contract which reads as follows. This contract shall be governed by the laws of the Federal Republic of Germany to the exclusion of laws, rules of private international law. Exclusion of the conflict of law rules of private international law. In litigation, both parties refer exclusively to German domestic law, but not to the CISG. And the question is, did the parties exclude the applicability of the CISG? And for you of importance is that Germany is a CISG member state. And if you look at these, so here, which is a decision by the Court of Appeal in Cologne, it's, as I said, 2 weeks old. So is this provision, the contract shall be governed by the laws of the Federal Republic of Germany to the exclusion of the conflict of laws, rules of private international law. Is that an exclusion of the CISG? First of all, we need to know, can parties opt out of the CISG? Yes, there is no doubt. Article 6 is very clear about that. It's all about party autonomy. Parties can opt out if they agree. They can do that expressly, and they can do that implicitly or impliedly. That is, there is no dispute. They can do it impliedly. They can exclude the CISG impliedly. The elephant in the room is how to interpret that provision, or that provision in the contract I just presented. Can we conclude that this is really an implied exclusion of the CISG? Did parties really want to exclude the CISG? We need to use Article 8 come to a result whether that's an implicit exclusion of the CISG or not. So what for potential points of reference do we have for an implied exclusion of the CISG in my little example? Could we argue that just by the phrase, this contract shall be governed by the laws of the Federal Republic of Germany, does that already suffice to exclude, to argue that there is an implied exclusion? There are some decision which says that suffices, but the leading case law and also leading legal literature says no, that is not sufficient, because the CISG is incorporated German law, because Germany is a member state of the CISG. So that is not an implicit exclusion of the CISG. But could maybe, together with the second half of the sentence, to the exclusion of the conflict of laws, rules of private international law, could that be seen, together with the first part, seen as an exclusion of the CISG? No. To the exclusion of the conflict of law, rules of private international law, because the CISG is a uniform law. It's substantial uniform law. It's not conflict of laws. And therefore, even with that second part, if you add that to the first part, it is probably would be the leading opinion that this does not lead to an exclusion of the CISG. And also the Supreme Court, now also the Court of Appeal Cologne said the same. But could we say, well, the reference during litigation exclusively to German domestic law by both parties, this leads to an implied exclusion of the CISG. Case law is divided. My impression is that the former case law said more that this suffices for an implicit exclusion, while the newer case law, and according to me, leading case law, said no, this does not suffice. Because if the parties are not apparently not even aware that the CISG does apply, they cannot implicit exclude it. So to have an explicit exclusion, they at least need to be aware that the CISG exists. And maybe, so also that does not lead to an explicit exclusion of the CISG. And then we could ask, well, if we have all those 3 points, if we put them together, if one single point doesn't suffice, but maybe all together, does that do the job? And can we say, okay, but if we have all these 3 points, that justifies an implicit exclusion of the CISG? Personally, I don't think so, that even that is not enough. But of course, if that would be a CISG case, then you would have enough to talk. Carlo, I think I'm done, right? With the, I mean, I can go on. I have many things to say. But,
yes, of course. And thank you very much, André, for this very important special focus on the CISG. And but not only on that, because really today you provided our mooties with practical guidance on how to address concretely the oral phase of the Vis Moot, which is starting in these days. So André, thank you very much for your generosity in delivering this lecture for us today. And I will break the ice for the Q&A session, and we'll go back to one of the practical issues which were on your presentation, namely rebuttals and sub-rebuttals. And so my question is very straightforward. So, Professor Janssen, how should be the perfect rebuttal for you, and how should be the perfect sub-rebuttal?
Yes.
André.
Well, thank you very much. I show you the screen just to, I believe, first of all, maybe the most important thing is listen. Listen to what the opponent says, and also listen carefully to the questions of the tribunal. So normally, if you listen carefully to what the tribunal says, you can already feel where the tribunal spots the weak points in the argumentation of the opponent of the opposing team, and that could be used. So in general, a good rebuttal and surrebuttal spots the weakness in the argumentation. This is when I see that, this is something I directly, these scores. So that student who sees the weak spot and who knows it, that brings points, that brings marks. In general, it is of importance is do not choose your battles. Don't come up with 3-4 issues. It needs to be crunchy. And so the rebuttal needs to respond to the oral submission of the opponent, and the surrebuttal needs to respond to the rebuttal. So you should neither repeat what you have already said. That this is something I see very often. Yeah, that they just repeat. The team just repeats what it already said. That's bad. But also, if suddenly sometimes they come up with completely new source, with a completely new fact, or with a completely new argument. And then I'm always wondering, okay, if the argument is so important, why you did not put it in those 14 minutes? Why you put it in these 1 minute? And it should be short, 1 minute, of course, and you should be concentrated. What I often see is that students are losing concentration at the end because it's only 1 minute. You say, okay. And I always think this is the last chance to shine. Yeah, that's the last chance. And normally a good rebuttal, I always write down whether rebuttal and surrebuttal is good. So it gives points. And always, I believe you should see it as your last chance to shine. This is okay. Here, that is, you should end on a high note. And what I also sometimes see, not often, is, and that is something I would really avoid, is that you let the chance to do the surrebuttal, that you let the chance to do the rebuttal and surrebuttal slide. Yeah, that you say, well, I've said everything. That is not good. So you should always say something. And in the best case, as I said, spot the weakness of the line of argumentation of the other, or line of reasoning of the other team. This is, I believe, the art.
Thank you very much, André. And maybe now, Irene, you can pose questions or pick any question from the chat box. Thank you.
Absolutely. Professor, in the same line of thought in terms of responsiveness, what advice would you give to students, especially second speakers, either on the merits or procedure, who want to balance between advancing their arguments and also being responsive to opposing counsel's arguments? How would you advise them to navigate that scenario?
This is difficult, which is true. So in the best case, I would, if there is the first speaker doing his or her oral arguments, and you go second, so you are the member of the opposing team. In that case, if you already see there are some weaknesses, and you can take these and insert it into your own presentation, that's good. So I love to see that, because then what I realize, and normally the arbitral tribunal, the other members realize, this is not robotic. So somebody spontaneous, somebody sees, I can see, because you can learn your oral arguments by heart. Yeah, you can memorize everything, but then it sounds very robotic. And this is what I don't like. And if somebody spontaneous sees already, and then I would say it's a low-hanging fruit and say, I spot the weakness and I insert it into my own response already. Yeah, and sometimes so when there is a source, when the first speaker uses, for example, a part of literature, and you realize, okay, that was misleading or something like that, because it only cited, the person only cited half of the sentence. Yeah, and the second sentence is in favor of your position. And this is something I really love to see. And that's like, wow, that's good. Yes, I hope I answered your question.
It does. Thank you. I think I'll hand it back off to Carlo to give us another question.
Yes. So, André, you are one of the most renowned specialists on the CISG. But I think you also mentioned that, I think it was in your presentation, we also have the UNIDROIT Principles.
Yeah.
So, also personally, so to say, what is your approach to this legal instrument? And to put the question more generally, are the CISG and the principles two planets apart, or do you see more synergy than clash? In a nutshell, if you may.
Well, I love the UNIDROIT Principles as an academic endeavor, but personally, I am careful to use the UNIDROIT Principles to either interpret the CISG or to do the gap filling with the CIs with the UNIDROIT Principles. So, according to me, I would be very careful using the UNIDROIT Principles for Article 7.1, so for the interpretation of the CISG. And I would be also very careful to do the gap filling, the internal gap filling with the general principles, and then argue that the UNIDROIT Principles are the general principles on which the CISG is based. And there is always, first of all, I believe that the UNIDROIT Principles are an academic project, very important. I love them. That's not the point. But then the CISGs of 1980 and the UNIDROIT Principles came much later. So I always have problems to argue that the UNIDROIT Principles, who came more than 10 years later, represent principles on which the CISG is based. While 1980, the drafters nobody knew about the UNIDROIT Principles. So that is my personal stance, but I know there are opposing views.
Thank you very much, André. Irene, do you have further questions on that side?
Perhaps one more question on the CISG, and it's topical to this year. As an expert on the CISG, I think some of us are really curious about your take on this year's problem, because it tackles the applicability of the CISG on two fronts, right? Whether the parties excluded the CISG and whether the CISG excludes itself because of the nature of the parties' transaction. Do you have an opinion on which should come first in oral arguments, which question takes priority? Because year in, year out, we see Vis students sort of change the order of the issues to make sure it flows better in an oral argument. So do you have an opinion on which should come first?
Yeah, well, I would do the exclusion second personally. So I would go first with Article 3, and then I would ask whether it's excluded. So according to me, that's the right order to do. Yes.
Well, I think, André, we can really share your approach to this question. We remember the famous unknown arbitrator who stated that it was advisable to put arguments in logical order, if not chronological, if not alphabetical. So perfectly fits with your answer. Now, I think, Irene, it's high time to close this fantastic session of the Edu series. So, André, thank you very much again. It was a great honor to have you here today. Many thanks for sharing your wisdom and invaluable expertise on the CISG in the Vis Moot. On behalf of Africa in the Moot, I express Irene's and my gratitude for having you with us today. I think invaluable food for thought for all our Mooties who have been connected online and also can listen afterwards to your lecture, thanks to our partner arbitration channel. André, thank you very much again. Thanks to Irene, my fantastic co-moderator, and I think see you in Vienna.
Yes, see you all in Vienna, hopefully, and wishing you all best of luck, and hope to see you all soon. All the best.
All the best. Goodbye.
Bye-bye. Cheers.